Hello, everybody. Welcome back to Law and Crime Network. We were watching Willis's statement today from his sentencing, and some shocking stuff coming out in his statement. He says, I mean, look, we're not surprised here. He's maintained this throughout the entirety of his trial. I am innocent. Our system of government relies on many principles, a fair and balanced approach to justice. So here, Willis is saying that he doesn't believe that he had a fair shake. He thinks his defense was lacking. I'm going to bring in our expert, law and crime legal analyst, Elura Nanos. Elura, so when I heard this statement, this was kind of hard to hear because as we watched the Willis trial unfold, I mean, we saw a lot of what I think we would consider aggravating factors, right? I mean, we saw all of those, the handcuffs, all of that other stuff that was found in the back of the truck. Very gruesome. We heard testimony from a kidnapping victim who had actually escaped. We know that he's already been convicted on the murder of Rebecca Bletch, and some of that information came out in the trial. So now, to hear Willis, who did, by the way, maintain his innocence throughout the entirety of this trial, this is pretty shocking stuff. He's saying you didn't get a fair shake. What do you make of that?
Well, I think it depends on what you mean by shocking. So, very often we see anybody who studies multiple homicide defendants, people who just are sick and twisted individuals, you'll see that what many of them have in common is this sort of deranged narcissism going on. And I think from that perspective, it's not as surprising to say that this guy probably believes that he didn't get a fair shake, right? He probably believes that he could have beat the system in some way. Whether he isn't aware of what his culpability is or whether he just really believes that somehow he's being victimized by the system, it's no surprise if you think about the fact that people like this are twisted. So it's not so crazy to think that he would say that. What is interesting, though, is to think that, how does that play for the people in the courtroom or for the people watching, where those type of words about the general criminal justice system might actually resonate with them? Because there are many people who are not murderers who do believe that the criminal justice system is seriously flawed. So it kind of becomes this interesting dance between what is real in the world and what is real with respect to this defendant.
Yeah, absolutely. And you make a really great point. Another issue that we can imagine that's coming up is the family in the courtroom. That, now Willis has been convicted and he's still pleading his innocence. He's still saying, I didn't do it. Again, he did maintain that throughout the entirety of the trial. So it's not surprising to hear him say it again. But, Elura, do you see this as just a Hail Mary? He said this is probably going to be appealed, as many murder convictions with a life sentence are. Is this that Hail Mary to say, look, no matter what the jury concludes, I am innocent?
I think in a way, yes. I would be surprised if you told me that this guy thinks that saying those things are going to materially help him in any way. But I think that people who maintain their innocence in the face of incredibly damning evidence against them often just continue to do that. And at this point, what's the difference? Right. He's already been sentenced. I mean, it's not going to affect the outcome in this trial. And he just doesn't seem like the type of person who is willing to accept any responsibility. And that, of course, goes in line with the type of mentality for someone who could commit this kind of crime.
Right. And he's already a life sentence of the Rebecca Bletch trial. Right. So, I mean, he's going to be in prison for the rest of his life. Now, one thing I thought was very interesting about the clip that we just watched in this portion of Willis's statement was that he was really specifically calling out jurors. He said one juror was caught Facebooking with another. A juror was chatting with the Bletch family and talking about how he believes that led to what he concludes in his statement is an unfair result. So what do you think about those statements relating to the conduct of the jurors? Will that ever hold any weight, or is that just seen as his own conjecture and something that maybe he can hang on to?
Well, I mean, I think it depends on what we do with that information. The fact that he said it in the courtroom is not going to be what holds the weight. But certainly on appeal, if his attorney can make credible legal arguments that jurors acted inappropriately, that there was something wrong with the deliberation process, that jurors communicated with people they shouldn't have at times that they shouldn't have, those things are actually extremely important. So I don't actually expect that in this case it's going to undo this verdict, but those issues are very real issues in our criminal justice system. So they can be sort of in a vacuum. Yes, those things can be very relevant, can be brought up on appeal. But we're not at appeal. Right now, we're at, courtroom statements after sentencing, which is a far cry from serious legal arguments made in appeal motions. So I think that I don't actually think it's going to make a difference to him in this particular case, but I also don't think that it's just nothing.
Right, because as we know, defense attorneys are going to do everything they can to preserve any possible and potential appealable issue. And something that we've seen time and time again in this Facebook internet era is that conduct of jurors online can actually lead to problems in the courtroom.
Sure.
So whether or not there's any merit to that, we don't know right now. This is, of course, Willis making these statements on his own behalf after sentencing. We do want to continue to watch Willis's statement from this morning. Here he explains something very strange that had happened at his previous trial, and I think that our viewers are going to be very interested. And Elura, I want to hear your take. So let's watch this clip of the Willis statement from earlier today.
CSD number 45018 back in 2014 for the reports GR 14-3508 record number 3, or yet again for the new report in 2016 record number 25. He knew that bullet, which was the only one remotely matched to my gun in 2016, was not taken from the body of Rebecca Bletch, nor did it match the two that actually did. The Supreme Court, in its ruling for Mooney v. Holohan, wrote of this type of miscarriage of justice in 1935. The court stated, "It is a requirement that cannot be deemed
Hello, welcome back. We're watching clips from Willis's statement earlier today. Now, this was at the sentencing phase of the trial where Willis was convicted. Willis was previously convicted, and this morning was sentenced to life for the murder of Jessica Haringa, plus 18 to 40-year sentence for her kidnapping. Now, remember, just to loop back, Willis was also serving a life sentence for the murder of Rebecca Bletch. And at the end of the Bletch trial, he did something which some would qualify as extremely disrespectful, but everyone would think was bizarre. He blew a kiss during the sentencing of that trial. He also, in his statement today, talked about how he was treated unfairly, how he didn't get a fair shake. And something else interesting, looking back to the Bletch case, he did not want to be in the room for the victim impact statements during that sentencing. And in response to that, because of Willis, a new law was passed called the Bletch Law, which required Willis to be in the courtroom to hear those victim impact statements. So it seems that there's been a lot of lack of taking responsibility for these crimes. Again, he has pled innocent since the beginning with the Jessica Haringa case. But I want to break down some of what happened this morning in the courtroom with Elura Nanos, our law and crime legal analyst. So Elura, this blowing of the kiss, now we saw that it's disrespectful. I mean, the family was outraged. The family thought it was towards them. Now, we hear Willis attempt to explain that away. What? To say that it was supposed to be, I don't know, it was a message to the prosecutor. It was mistakenly construed as a hateful kiss. I'm reading the transcript because I want to make sure I get it right. But in what world is that ever going to be an appropriate thing to do?
Of course it's not going to be appropriate. And honestly, everything about this case, this defendant, to me, it feels like I'm reading like a James Patterson novel. That's what the kind of persona that I'm getting. Like this ultra arrogant, narcissistic lunatic who is out there for his own pleasure committing violent crimes. This is not a situation of a bar fight gone wrong, or even a robbery gone wrong, like we've seen with the other cases that we're covering today. This is a situation that is born of serious criminal twisted intent. And it is with those type of criminals that it's not surprising to see that they expect, for example, to be able to conduct their own trials the way that they want, even when it's absurdly unfair to everyone else. It's not shocking that a defendant like that would feel somehow wronged or outraged or unfairly treated because he was convicted, or that he would even taunt the prosecutor or the victims' families, because these individuals are, they have some serious twisted criminal minds. And these are not people who just ended up in the wrong place at the wrong time and made a bad decision. This is a person who committed a series of extremely violent, horrific murders and a kidnapping. So it doesn't really surprise me. What does make me kind of take pause is the idea of, look at what happened. He acted totally inappropriately in the courtroom in a way that was obviously hurtful to the family, who should never be made to bear any more pain. And what happens? Immediately, there is a law passed to prevent that type of thing. And we see that a lot in criminal law. We see legislation that is reactionary after something terrible goes down in a courtroom. Now, in this case, I don't see anything particularly wrong with it. I think convicted criminals should have to listen to victim impact statement, and I think that that's totally appropriate. But I think as a general concept, when we see that happening, that something happens in a courtroom and we don't like it because a particular defendant, is extra bad in some way, and then immediately there's legislation that comes as a reaction, I think that can be a very dangerous way of legislating.
Yeah, and I also think from that perspective, you're right about that, but also just his actions in the courtroom. Willis has the opportunity to get up there, and what he's theoretically supposed to be doing is setting forth facts that might mitigate the sentence. He's supposed to be saying, these are the reasons why, yes, I was convicted, yes, I've been found guilty by a jury, but this is why I should have a sentence that's lesser than what the maximum might be.
That's right.
I don't think he did himself any favors.
He certainly did not.
Trying to explain this away with this, really just flimsy reasoning.
Right, and I'll tell you that from a prosecutorial standpoint, or even a judicial standpoint, there's a part of me that looks at this and says, obviously that behavior is really reprehensible, but from a legal standpoint, it almost makes things clearer, and I appreciate the clarity, because when you have someone that is unrepentant, you have somebody that their story has never changed, they're not interested in taking responsibility, in fact, they're looking to antagonize victims of a violent crime. What it does as someone who is looking on is it gives me no sympathy for this person. And then when they get sentenced to 40 years or life sentences or back-to-back, I don't care. I don't have that kind of, I don't have that kind of emotion that I might in a different case. And sort of as a matter of practicing law, it sort of makes things easier, because you can look at that person and say, I'm glad he got convicted, for the jurors as well. I'm glad he got convicted. He's not showing remorse. He deserves to rot in jail. And it sort of, you can do that without any hesitation, sort of.
Well, yeah, certainly interesting points. Thank you, Elura. We're going to continue to watch Willis's statement. Again, he was convicted during the guilt phase of the trial, which we covered here, gavel to gavel. There was some evidence that came out that was very hard to watch. It almost seemed like the makings of a movie, a horror movie, because of how extreme some of the testimony and some of the evidence that was presented and what was found, what was found during that trial. But again, Willis had pled his innocence throughout the entirety of the trial. He was convicted by a jury, and this morning was sentenced. So we're going to continue to watch his statement in these post-trial proceedings here.
The jury press.
Jeffrey Willis was sentenced to life in prison plus 18 to 40 years for the murder of Jessica Haringa in 2013. We're watching his statement earlier today in the courtroom, where he presented to the judge his version of the facts here. Now, he's saying that he's innocent. He's blaming investigators, saying he was unfairly targeted. He's saying his defense was not what it should have been. He's saying that there was misconduct of the jurors. He's essentially blaming anybody and everyone he can for his conviction. He is not taken any responsibility. Again, since the onset of the Jessica Horinga trial, Willis has maintained his innocence. He has said that he did not do it, that he had nothing to do with Jessica Horinga's death. Obviously, a jury felt differently. After only 90 minutes, he was convicted for Jessica Horinga's murder. I'm here with Elura Nanos, Law and Crime trial analyst. Elura, so let's talk a little bit about what the purpose of these statements are. We were able to touch on it before, but we haven't really broken it down. So with these statements, this is the sentencing phase of the trial. So there's the guilt phase, which is determined by the jury. We watched that trial gavel to gavel here on the Law and Crime Network. All of the evidence was presented. Ultimately, a jury concluded that Willis was guilty. Now, we move on to the sentencing phase of the trial. Here, Willis, his defense, has the right to put on what would be considered mitigating factors, right? So it's what he believes would be something to influence the judge to lessen what the potential sentence could be. So that's what we heard. That's what we're hearing right now. Do you think he hit the nail on the head? I mean, this really didn't make me feel too sympathetic for him.
No,
as an outsider.
It really didn't. And I think that the reason for that really is specific to this case, because I think there are cases that a defendant could go and make a statement about justice and Lady Justice is weeping and why this is so unfair to them, where it actually could hit home. But this just is not one of those cases. It wasn't a close case. The jury deliberated for 90 minutes. The evidence was overwhelming. The crime was incredibly gruesome. Factually, there was basically nothing to mitigate it. I mean, there are cases that there are factually mitigating factors where, yes, the defendant is guilty, but a reasonable person could sort of understand something about why the person acted that way in that situation. This is not that case. These are totally innocent victims, victims of a horrific crime. We know, of course, that the guy is already serving a life sentence for another crime. So, I mean, it's really falling on deaf ears, although, I give him credit for putting it together nicely. He's got Supreme Court precedent, he's got religious references. He's got like throwing everything in the kitchen sink in there. It's ultimately not really.
Yeah, I mean, he did his research. I mean, it was a tough case for the defense team because the jury heard about the Rebecca Bletch conviction, which sometimes wouldn't necessarily be a part of the trial. Also, they heard from a potential kidnapping victim, a trial that he will be facing in the future, in the not too distant future. He referenced her, by the way, that alleged kidnapping victim who had taken the stand,
just going to help
saying he was just trying to help her. But okay, either here nor there. It's his right to make that statement. Sometimes when you hear the defense put on a statement at the sentencing phase of the trial, the defense attorneys will get involved. They might talk about some sort of issues that somebody had in the past. They might talk about mental health issues. They might talk about anything that
can be very compelling.
Absolutely.
Yeah.
We didn't hear that here.
No.
Now, just to bring our viewers back, Rebecca Bletch trial, which is not the trial that he's being sentenced for today. It's the case that he's serving a life sentence without parole already. That trial, he testified on his own behalf, right? Willis testified. In the Horinga case, he did not. Probably a smart counseling on the part of the attorneys. And now he's getting up and he's making this statement, seemingly, these are his words. He's getting up there, he's saying it. What do you think the defense attorneys are thinking? Do you think that was their advice? Were they saying, I don't know if you should get up there, maybe we should talk about some of your history, your past, or other factors, or just get up there and tell your story? I mean, that's kind of a strategy call at the end of the day.
Sure, and I mean, I would have to guess that the defense lawyers would have counseled him to bring up something relevant. I don't think it would be that one would have to be some sort of mastermind defense lawyer to say, let's come up with something sympathetic about this man. Even really horribly hardened criminals often have something very sympathetic in their background, whether it's a history of abuse, whether it's health issues or mental health issues. There's often something that the person can say to just soften the jury. It doesn't alleviate their guilt at all, but it can soften the jury toward them. And I'm sure that Willis's attorneys knew that and probably said, hey, this is what we think you should say. But if I had to guess, he strikes me as someone who follows that profile of someone who thinks they're smarter than everyone. Often criminal defendants think that they are smarter than their own lawyers, particularly criminal defendants that have serious mental problems, like someone who would commit heinous crimes like this guy did. So it doesn't surprise me that he would just kind of do what he wanted to do anyway. I'm sure his attorneys told him not to say those things and maybe suggested things that would have mitigated at sentencing. But likely, I wouldn't be surprised if this was like a hands in the air kind of fine, say what you want. It's not going to matter anyway. You're already serving a life sentence anyway. So from a legal standpoint, as a defense lawyer, yeah, you don't want to allow your client to do something where then on appeal, a court is scrutinizing your decisions as a lawyer, even if the client ultimately, somehow is helped by it. You don't want to be the cause of ineffective assistance of counsel. But in a situation where the person is already serving a life sentence, the danger is a little bit less because, he wouldn't be walking free anyway. And I wouldn't be surprised if he was kind of a difficult client like we've all had, that you tell them to do one thing and they just do something else.
Right, and it's his right. He can make the statement, absolutely. You, as an attorney, you can counsel over and over. Here's the good, the bad, and the ugly of making any single decision in the context of the case. But if he wants to make that statement, then he does. So who knows how much of a hand the defense attorney actually had in it. But while Willis had the ability to make that statement, the prosecutors were also able to put forth a statement and essentially asking for the maximum penalty under the law. So we're going to watch the prosecution statement now. No ounce of dignity, no remorse. One of the most dangerous men I have ever encountered. That was the prosecution's statement. And what did we hear? We heard applause erupting in the courtroom after the prosecutor concluded their statement about Willis. Elura Nanos, thank you so much for joining us today. I mean, this is really, there was a lot that happened during the sentencing, and it was a bit unique because you did have Willis up there making his plea, again, maintaining his innocence, again, making certain explanations and excuses for some of his conduct during the trial, pointing the finger at everyone, investigators, the prosecution, his defense attorneys, and the jury. But the prosecution statement, short and sweet, but really got to the point. How did you feel about it? I think they did an excellent job.
I think they did an excellent job. I also just wanted to call attention to that one word, dangerous. Prosecutors, they can be, hyperbolize as much as anyone else can, but prosecutors don't tend to call every single defendant dangerous. They might say this crime was a terrible crime. Prosecutors often look back and they look at what the person was convicted of doing, and they say, this was awful, and these are the factors, and that's what they do. But when they use words like dangerous, what that's really doing is looking forward, not looking back, and saying, if you let this guy out, he's going to hurt somebody else. That's what that means in a courtroom. And it's different than saying, hey, we just want to punish. It's kind of bringing up the idea that we want to keep this person away from society to protect the rest of us. And in my book, that's the most compelling thing a person could say on sentencing. Because if I'm a judge, I want to protect people in the future first and foremost. And then things like retribution and compensation to society, those things are important too. But there's nothing that would inspire me more than saying this professional just said to me that in 20 years, this is the most dangerous guy he's ever come across. That would mean something to me as a judge, and I think it probably meant something here.
Yeah, absolutely. And he said, look, the jury got it right. He's going to sleep well tonight. The prosecutor made that statement, so that was all very compelling. But I do want to talk about one piece of this, because it is interesting, and to play devil's advocate, we saw a lot of overwhelming circumstantial evidence against Willis in this case, in the Haringa case. We know that the Bletch case was discussed during the trial. The jury heard about it. Also, this attempted kidnapping that he will be facing trial for in the future. But there wasn't any forensic evidence. There is no body. I mean, no body murder cases are often very difficult to prove.
Right.
Despite that, he was convicted. How much of the case, the actual guilt phase of the case, can be relitigated during the penalty phase of the trial? Because I think as a defense attorney, I would have focused on those facts. Yes, the jury came back with a guilty verdict, but look, He still maintains his innocence. There's no body, and there was no DNA evidence linking him to the crime.
Yeah.
So that might have been a more effective strategy.
I think that would have been very smart, and I think that as a defense attorney, what you want to do is you have to use what's available to you, and every case has different things. Sometimes you have a very sympathetic defendant, sometimes you have an unsympathetic defendant, but a disaster of an investigation. So this is a situation that although there was sufficient evidence to support a conviction, when you have a murder conviction and no body, that in and of itself is pretty significant. And if I were the person dealing with the mitigation factor of the sentencing, I certainly would have made a giant production out of that. In fact, if more had been made out of the lack of evidence, out of the consistency of this defendant maintaining his innocence, a lack of physical evidence, and all of that, perhaps Willis's kind of go-to statement of everything is stacked against me and the whole justice system is corrupt and I'm a victim of it, maybe he could have said less about that, but it might have actually played better if there was some evidence like, hey, I was just convicted of a murder. We don't even know if the person's dead. There's no body. That's actually a pretty compelling thing to bring up. But if you don't bring it up and you don't make anything out of it, then all of these kind of flimsy arguments about how everything poor you and boohoo because the criminal justice system is flawed, that really just doesn't go anywhere. They really should have focused on that lack of evidence.
Yeah, certainly that would have been a strategy that could have been employed.
Absolutely.
But again, Willis had the option of making a statement on his own. He did so. It is his right, and he did that during the penalty phase of the trial. We heard that earlier today. Now we just heard the prosecution statement to the court. Now we're going to listen to the judge's decision. Take a listen.
Attorneys are aware I have several cases pending involving this particular defendant, so I don't intend.
This decision in the Jeffrey Willis case. Jeffrey Willis this morning was sentenced to life in prison for the murder of Jessica Haringa, plus an additional 18 to 40 years for her kidnapping. Now remember, he's already been convicted previously in the murder of Rebecca Bletch and is serving a life sentence without parole. So now he's facing 2 life sentences without parole, additional 40 years. This guy's spending the rest of his life in prison. The prosecution, during their statement to the court during the penalty phase of the trial, said, "This is one of the most dangerous men I have ever come across, and I will sleep well tonight knowing he's spending the rest of his life in jail." Elura Nanos, Law and Crime trial analyst. So now we heard what the judge's decision was. Look, he's facing the maximum sentence here. He's in prison for life on this case. The judge was obviously swayed by the prosecution in this case.
Yeah, the judge probably was affected by the prosecution, and I wouldn't be surprised if the judge was already planning to impose that type of sentence, regardless of the prosecution's sentencing statement. The details of this crime are pretty gruesome, and when you have those kind of facts, it sort of strikes me as the kind of case where it's like, well, if this guy doesn't get the max, then who does? And I think that comes through. Even you could poke your head into the trial for this for just a little while and sort of get that feeling. So I do think that what the prosecutor said had, maybe had some effect, but I really wouldn't be surprised if the judge was really going to do that anyway.
Right. So we had the penalty phase this morning. The judge made a determination about sentencing. Now, look, most of the time in these types of cases, when you have a conviction, you're going to see the defendant appealing that decision. Mm-hmm. In this case, look, of course, the defense attorneys were vigilant about making sure that any appealable issues were earmarked, that they made the proper objections, that they've preserved all of those issues for later. What do you think about the prospect of success on what I believe to be something that maybe they could hang their hat on for an appellate issue, whether or not it's successful? The fact that we heard about Rebecca Bletch, the fact that we had the alleged kidnapping victim testify during the Haringa trial. Now, could there be an argument that that was more prejudicial than probative, and perhaps that swayed the outcome of the trial? Would that be a valid appellate issue?
That certainly could be an argument, because generally speaking, when we're talking about a crime, things that happened to a different person on a different day, a different time than what is at stake in the trial are not relevant, right? And even if we can find a way that they are relevant, because let's say there's some kind of modus operandi going on, or it's some kind of a sequence sequence of events that's connected in some way. It has tremendous prejudicial value. The problem is it also has tremendous probative value. So we think about those. If I were an appellate defense lawyer, I might make a motion based on that. I don't think it's going to prevail in his case, but I wouldn't be surprised if we saw that argument raised, because it's not a nothing argument to say, look, I didn't get a fair shake today because I committed this other crime before, and that was brought up, and then everyone just assumed that I committed this crime too. That's a very valid argument. And in a case where you have a multiple murderer going on, that's perhaps not the best illustration of why we have that rule. When you have a situation where someone committed a crime 10 years ago and now they're on trial for a totally different crime and we don't want the old crime to come in, that's really why we have this rule, because it could unfairly prejudice the jury. In this kind of case where there is somewhat of a connection between these crimes in terms of the manner of the crime, what it is, I think that argument is much less likely to really work in this defendant's favor, but I wouldn't be surprised if we saw that as the basis for an appeal.
All right, we have to keep our eyes open. Of course, this is all fresh today. Willis was sentenced to life in prison, plus an additional 18 to 40 years for the murder and kidnapping of Jessica Haringa. He is facing another trial for another attempted kidnapping, and we will be covering that here on Law and Crime and talking about the impact of this prior trial on that once that date becomes closer. In the meantime, we're going to cut to a commercial break now, but when we return, more on the Marine murder trial. Trial is underway in the Marine murder case. Two men are facing the death penalty in the killing of a Marine. Canada and Millism are accused of killing Jonathan Price and injuring his wife Megan outside of a Lexington bar in June 2014. The two are facing the death penalty for this. Now, we've heard some testimony so far in the trial. We heard the opening statements of the prosecution and the defense. The defense is saying this is a case of misidentification, that the defendants are innocent, and that the prosecution simply has the wrong guys. We're going to watch this package to catch up on the facts of this case.
The Kentucky trial of the shooting death of a Marine is underway. 26-year-old Quincinio Canada and 34-year-old Dewan Mulazam are charged with murder and assault for an incident outside a bar in 2014. The two men allegedly approached Corporal Jonathan Price and his wife Megan when one of them tried to snatch her purse. When Jonathan got involved, a fight started, and the corporal was fatally shot in the back. Megan suffered a non-fatal bullet wound to her leg. Both men are also charged for a robbery 6 days prior to the Price shooting. Law enforcement connected them to both crimes by identifying the .45 caliber handgun used in the robbery and the shooting. For Law and Crime, I'm Rachel Stockman.
The Marine murder trial is live in the courtroom today. We will be back live in the court as soon as we can. We heard some testimony earlier today from investigators regarding the collection of evidence, and we saw the defense, their strategy to poke holes in the way that evidence was collected. The defense theory of the case that we know from the opening statement is that the prosecution simply has the wrong two people, and that the defendants are innocent. In setting forth their case, the defense attorneys are looking at all of the evidence presented and talking about the collection of evidence, talking about the fact that no other potential suspects were looked at in the case, and really taking some of the investigators to task. Elura Nanos, Law and Crime trial analyst, is here with me today to talk about this case. Now, Elura, there's something interesting in this case because you have two co-defendants here, right? We have Canada and Mulazam. They're both being tried together. Now, in some of these cases, we've seen they would have separate trials, that the defense might be split. Now, while they're both separately represented, this case is going on together. Is there a rationale behind that for the defense?
I mean, basically, the rationale must be that for the defense, that at least right now, that they're sort of united in their defense. And that makes sense to me, given that the defense is it's somebody else. It's neither one of these guys. You know, they're both represented, I think, by public defenders here, which means that the public defenders are likely from the same public defense office. So who knows what kind of internal politics there are going on there. I know that the overworked public defenders schedule was one of the reasons why this crime has taken so long to actually come to trial. So I think that there's a number of factors in play there. And we'll see if that ends up being helpful to the defense. I mean, often you have defendants who sever, who make a motion to sever the cases so that each defendant gets their own individual trial, so that, number one, whoever goes second can learn from whoever goes first, to hear what, let's say, witnesses say or what works and what does not work, or potentially have the opportunity to flip on one another. Now, my understanding is that these two men who are on trial are relatives of each other, so that also may have something to do with the decision, because they may be going into this and saying, no matter what, we're not going to flip on each other. We are united both in the defense and in kind of the concept of what our story is going to be.
Right,
so,
right, and absolutely. And then since the story, as we know, is that, hey, this is a case of mistaken identity, it makes sense that if they're saying, well, this had nothing to do with us, we are not the people that did it, that there would be no need to separate that defense. Interestingly enough, in furtherance of that defense theory, and we'll listen to this a little bit later, but one of the victims, Megan Price, who was actually shot in the leg on that fateful night, she was unable to do a positive identification of these two. So how does that play to the jury? This is early on in the trial, by the way.
Right.
So that's going to be something that will stick in the jurors' minds.
It's interesting that you bring that up, because when I first saw that she said that she was unable to really make a clear identification, the first thing that I thought was, given that this was like an attack, like they didn't know each other. Now she's saying she's not even sure it was them. They're pleading mistaken identity. It sounds as if her inability to make an identification supports the defense theory, or the defense of somebody else did it. But there's also another way of looking at it, and one of the things that Megan Price said was, I just wasn't comfortable making that identification. I didn't want it to be me. I forget what her exact words were, but she basically said, like, look, I can't be totally certain, so I don't want this whole thing to hinge on my identification. I think that in a way that creates unbelievable credibility on the part of this victim, because what she's saying is, look, I'm not 100% sure it was these defendants. I didn't pick them out of a lineup, so her identification can't be challenged because, she confused one person with another person. In fact, the identification portion is now left to more forensic evidence, which is more reliable, really, than, witness accounts of identification are notoriously unreliable. So now we've kind of taken that out of the equation, and now we're looking at other evidence to link these guys to the crime, which has the potential to be more powerful, assuming that there's enough of it. So I think it's a risk, but I actually think it may be a very smart move, because she's kind of presenting herself as someone who is so committed to making sure justice is done, as opposed to just getting anyone for this crime, that it's almost as if every word she's going to say has that much more truth to it.
Yeah, well, certainly, especially in the face of such tragic circumstances where this man lost his life in the course of a botched robbery. Only time will tell what the evidence will reveal as we move through the trial. But some of that evidence that's collected, which is the most compelling in a case like this, is that which happens at the time of the crime. So right now we're going to listen to the 911 call from that evening.
Let's do the 911.
I can't see too much. That is really about to keep that shot.
Okay.
Right now, too much.
Okay, man, I can't understand you. Where are you?
I can see touching that. My husband and I both took that shot. Praise.
What is your name?
Megan Praise.
And did you see who did the Megan?
Two black guys.
Did they leave in a car or on foot?
On foot. My husband came bad. I can't move my leg. He shot my leg.
Is there anything you can remember about them?
Two black men.
And that's all? Did you see the guns?
Both had guns. One had dreadlocks. White shirt.
Which one?
The one that shot me. They threw my husband into the truck. Into a truck. Jonathan, I love you.
I'm going to get you when we get there. They're all on the way.
Welcome back to the Law and Crime Network. We were just listening to the absolutely heart-wrenching 911 call made by victim Megan Price on the night of the Marine murder in question here that we're watching the trial today. We're supposed to be back in the courtroom in about 10 minutes, so we're waiting to see some activity in the courtroom, and we will go back live to hear more testimony. But before the break, we listened to the 911 call by Megan Price on that fateful night, and it was absolutely gut-wrenching. I mean, the emotion was palpable, and I can only imagine what it was like in the courtroom. Elura Nanos, thank you so much for being here. Now, we just listened to that 911 call. The emotion was, you could just hear it in Megan's voice. It was absolutely terrible. And to think that that was all the result of a botched robbery.
Yeah.
It's horrific.
You know, I mean, even the two of us sitting here in a studio, totally detached from this crime. We don't know these people. We're not seeing them. We're hearing, just a tape of the 911 call. It was pretty upsetting even for the two of us sitting here. I mean, this is really upsetting and absolutely terrible. And I can only imagine in the courtroom, the amount of emotion and what that does to these people, the jurors in particular, as they're sitting through this trial. That's going to stay with them through the trial. That's something that's, it's not easy to get over. I think 911 calls, I think they're some of the hardest things to hear. And 911 call that's called by a victim. Let's not forget, Megan Price is a victim. She was shot, and it wasn't even as though she was just grazed. She had a serious injury. She's now had multiple surgeries. She has like rods in her legs, and in order for her to get rid of the rods, she's going to have another surgery. She's a serious victim in her own right, having nothing to do with being a widow. It's pretty terrible. And listening to her try her best to describe what's going on, at the same time, talking to Jonathan and her dealing with her own pain and obviously sounding afraid. It's a lot to take in. And I think that it sets the tone for this case. And I think that that's just going to be something for the defense that is nearly impossible to circumvent for the rest of the trial.
Right. Absolutely. I mean, that 911 call, you could hear the fear in Megan's voice for her own safety. You could hear the fear of the possibility of losing her husband and not necessarily knowing the nature and extent of his injuries. And all of that is certainly going to play on the emotions of the jurors. Now, does that matter in the course of this trial if we have the wrong people at the defense table, which is the defense theory of the case? So that certainly is going to be the big factor. Interestingly enough, as with many 911 calls, that's a great account of what happened from an evidence perspective, because that's contemporaneous.
Right, it's happening at exactly the same
that
time.
moment. It's when memories are fresh, when you're going to have the most information at that moment of what's happening around you. Now, of course, she's a victim, she's shot. That can cloud the mind, but she did give at least a cursory description of her assailants.
Yeah, she said there are two black men. One is wearing a white shirt, and the one wearing a white shirt had dreadlocks, which, it matches the description of these defendants. Of course, it matches the description of many people. These are not the only two black men, one of which having dreadlocks in the world. So, that's hardly, it matches, but that doesn't prove the case one way or another.
Right. We don't have a dispositive identification there, but certainly we have another feather in the cap as far as consistency.
It doesn't look good.
To the identification.
Right. If I'm the defense attorney, I'm hoping that my clients either, somehow don't fit that description, and they do fit that description. And I think that you put it together, it's a quick ID. Yes, it could be other people. But I just really think it's difficult to get around, especially in the context of how painful, both physically painful and emotionally painful, it sounded like in that moment. I think it's going to be something that, as you said, really does stick with the jury.
Absolutely. And so the prosecution today, which we expect to be back in the courtroom in about 10 minutes, but the prosecution today, we're hearing a lot of evidence. We're hearing a lot about the investigation. We're hearing a lot about forensics. We're hearing about some of the nitty-gritty of the case, which is important to put together the puzzle. But we know where the defense is going. We know the defense is going to say that there's DNA evidence out there that exonerates the defendants. Now, again, prosecution's case is on. What we're hearing now is the defense poking holes in the way the investigation was conducted. Why did this take longer than that? Why didn't you look into the XYZ person? Possibly proposing alternate theories of the case. Do we expect to see more of that as time goes on, Elura? What do you think the defense is going to do here?
I do think that the defense is going to make a lot out of that. I believe that one of the accounts that I read was that the victim here had DNA under his fingernails, but not DNA that matched either of the defendants. I think that can be important because it brings in that possibility of a different person. But let's not forget, this is not just the crime of the shooting of the Prices, but there is a connection to this robbery 6 days earlier where the gun is the same gun. And, you know, it's not as if the prosecution only has whatever evidence from the shooting. There is also this connection with the gun. And I think that that seriously strengthens the prosecution's case here.
Yeah, certainly that's going to be a big factor. Now, we're watching David Walker, an AT&T cell phone expert who has been testifying for the most part about just laying the foundation for his testimony. We did see some pictures of a cell phone tower. We haven't really gotten into the meat of his testimony, which we anticipate will be specifics regarding cell phone towers, pinging of the towers, and the location of the phones that could be critical evidence in this case. Now, cell phone experts are now, it really is something that you're going to see in every trial because we have experts in this field who cell phones are just so commonplace now. Everyone has one. So it is a tool, an evidentiary tool that's often used, and that's what we're seeing now, and we anticipate the testimony is going to go in that direction. But cell phones, the internet, Facebook, all of this has really changed the terrain of the legal system. I have Elura Nanos here, law and crime legal analyst. So Elura, obviously we do anticipate that at some point we're going to be getting into this testimony that's going to be more specific to the defendants, perhaps talking about their location. Now, while we can usually get an idea of the vicinity where somebody is based on the pinging of the cell phone towers, it's not always exact. So we're probably going to be seeing some version of that that's going to be attacked by the defense if it's a problem for them. But what do you think we're going to see here from this expert?
Well, I imagine if we have the cell phone expert on the stand as part of the state's case, that, you know, within some degree of certainty, there is going to be testimony that the cell phone records show that these two defendants were in the general proximity of the place where the murder took place. So, I mean, I expect that the expert is going to say these two defendants were there the night of the murder. The question is, what does there mean? Does it mean within a block? Does it mean within a mile? And I think we're going to, the level of specificity of the location is going to be important because, of course, the defense is going to have to attack it and say, well, we were there, but not there. We were in the neighborhood, but not in that parking lot. And, you know, it's unlikely that the cell phone experts, you know, credibility or record keeping, anything like that, is really going to be at issue. But what is more likely is that, you know, it will get within a vicinity, but the vicinity will still be ambiguous enough that we don't necessarily know if these defendants were exactly where the Price victims were at on the night of the shooting.
Right. So now we have this expert on the stand, and he's testifying really in relation to an interpretation of the record. So that's his function, to talk about what that means. We did see a picture of a tower, so I anticipate that at some point we're going to see more about what that tower means and locations of phones and whatnot. But could we also see something about text messages and other communications? Is that something that this expert may testify to?
Sure. I mean, we certainly could see that. We could see the defendants perhaps texting each other or other people about where they are or where they were meeting up or what they were doing that night. That would certainly be very common, you know, for people who are going someplace together. I mean, we don't know if there are such text messages or if there are what they might say, but that absolutely could be the case. And I think one of the things that is interesting to see here is that cell phone testimony, expert witness testimony about cell phones and towers and location is becoming so common that it's going the way that DNA evidence came. You know, DNA evidence, when it started, was like this totally new, novel scientific type of evidence. The jury really needed a lot of explanation about what it was and how it worked and what it meant. And now, although that evidence is still there and still requires explanation, jurors and courtrooms in general are kind of willing to say, yep, we know that this is just sort of part of how cases go very often. And I think that's what we're seeing happening with cell phone testimony. You know, initially it required a lot of explanation, but now, you know, people are getting used to it, that this is happening in so many trials because, as you said before, cell phones are such a common part of life. So, you know, I'm sure we'll see more and more of this. You know, sometimes we get cell phone testimony that is super exciting because it actually has things like text messages, and maybe we'll see that. And sometimes it's just something more commonplace like location. But I expect to at least see the location here.
Right, and in these types of cases, cell phone testimony can actually crack the case sometimes, right? So the locations of phones, that can be very, very important and compelling evidence, especially in a case like we have here, because we have the defense saying these two did not do it. This is a case of mistaken identity. So everything the prosecution is doing would seemingly be in furtherance of knocking that down and saying these were the two guys that were there.
Yeah, if there were ever a case when cell phone testimony for location were important, this is it. Because when you have a case where the defense is, it wasn't me, I wasn't there, it was some other guy, that is the type of case where testimony putting the defendant there is the most important thing you could have. And here, as we were talking about before, the victim, Megan Price, we have a sort of half eyewitness identification. She gave some identifying characteristics of the assailants, but she couldn't say conclusively that it was actually these defendants. So absent that type of ID, we need something to say that these specific guys were there. So that cell phone testimony in this case is going to be extremely important.
Right, and you could see the prosecution doing that too, kind of putting the puzzle pieces together, as opposed to having that one eyewitness who's going to make that lock-solid identification, since we don't have that there. So we know that this expert is on the stand for the prosecution. So the prosecution called this witness. So we can anticipate there's going to be something in there that will be important. Now, if that's the case, do you think the defense may have somebody come on and rebuttal if you're talking about the pinging of towers? I mean, we've seen this before, that the tower pings here, and the reason that it pings there could be any number of reasons. Well, you don't necessarily have to be within X amount of miles for that tower to have been implicated. So do you think we might see rebuttal expert witnesses in this case?
I think we might, but I think that that's going to depend on it's going to depend on what the cell phone testimony is from the prosecution.
Right.
Because if the cell phone testimony from the prosecution is still a kind of a wide area, then maybe the defense is going to say, we don't need our own expert. The cell phone testimony from the prosecution says these two guys were like exactly where the crime took place. They're going to have to do something.
Then there might be a problem for the defense. So only time will tell. But right now it appears that the witness is now testifying. Again, he's testifying as to AT&T cell phone records. Take a look. Those are today's top stories. Now, I want to talk about one of these that's really making headlines. And this is the Walmart case that we just saw. Thomas Daniel Frudacker faces charges of theft, criminal damage, and fraudulent schemes, according to the Yuma County Sheriff's Office. Now, this is all after being arrested for allegedly making over $1 million in fraudulent returns to Walmart. Elura Nanos, let's talk about this case. I mean, this seems a little bit crazy because you think, how can you be making fraudulent returns? If you're returning the items, how can that be?
Yeah, I mean, there's a part of me that looks at this and says, well, you know, when you're talking about a return, right, I think most people would think that as long as the store representative okays the return, everyone is consented. It couldn't possibly be fraud. That's not really true. I mean, there are many transactions that at the point of the transaction, the victim party, let's say, thinks that everything is okay, only to then later find out that the circumstances of the transaction were indeed fraudulent, which is likely the case here. I think at least those are the allegations, that this guy returned things to Walmart that had not been purchased at Walmart. And by taking them back, the store hasn't given up its right to assert some kind of legal argument. No one expects the cashier who's taking in the return to investigate whether or not the thing had been manufactured by Walmart. So, this guy could face some pretty serious legal consequences.
Yeah, absolutely. But what I think is interesting about this, because in addition to those allegations, we also have him, and this is the way he was caught. Police said that he was there to return a computer that he brought, but he removed parts from it. Now, I don't know about you. If I'm the worker at Walmart, I'm not going to know if there's parts removed from a computer. How would I know? And it turns out that he returned one to one Walmart, the Walmart where he was caught, and there was something suspicious about the transaction that set off, the alarms. But he had done it earlier that day at another Walmart.
This guy is like the Walmart version of Catch Me If You Can, right? Like in the beginning, the guy is lifting the stickers off of the Pan Am toys, and turning it into this major counterfeiting scheme. This guy is single person, able to individually buy expensive things or find them somehow and then return them. So here's my question though, where is he getting this stuff from? Or is the fraud that it wasn't actually purchased there, or is it, it may be a situation where he purchased the computer, took the guts out of the computer, sold the guts of the computer to someone else, and then, because computer parts can be taken apart and sold, and depending on what it is, could be expensive. So maybe he took the processor out, or he took memory out or something, and then returned sort of the shell of the computer to Walmart, which would certainly be pretty shady.
Yeah.
I'm amazed that he got away with it to this extent. I mean, they're alleging $1.3 million. That's a lot.
$1.3 million of loss to Walmart. But another piece of this that I find to be so interesting is the fact that there's a lot of effort being put into this.
A lot of
as
effort.
you said,
a lot of effort.
There must be something resold. There has to be some sort of financial benefit for the defendant here in this case, because he went to over 1,000 Walmart locations nationwide. Those are the allegations.
I don't think I would go to 1,000 Walmarts, even for one.
In my lifetime, right? I mean, 1,000 Walmart locations nationwide. That is absolutely, that must take a lot of planning, presumably. Travel. So,
seriously, Walmart should hire this guy. Honestly,
as a consultant,
or other large stores. In all seriousness, this guy has developed what must be a system that is successful for him. He has done it on a large scale. It's not like he did this at 2 stores. If he's doing this at 1,000 stores, that tells me that whatever he's doing didn't raise flags at many different locations in different places, different staff, different stores. So I would really want to know, as a store owner, how did he do that? What did he do? Did he have help? Because here's the thing, if he's doing this at Walmart, is Walmart the only place he's doing it?
Yeah, who knows what will be uncovered? Yeah, that's a great point, Elura.
I mean, who knows? Walmart's certainly not the only place that is selling things, so who knows? I mean, this could, I have no reason to believe it's Walmart only. Unless maybe, if it is Walmart only, is that because Walmart has some specific store policy or operating procedure that makes them particularly vulnerable to that type of fraud? I mean, in all seriousness, I really think that retailers should look at this case and look at this guy and see, how was he able to do this? He's 23, he's a young guy, and he was really able to pull off what sounds like quite a caper. So, I'm interested to know what the details are here.
Yeah, I mean, you were reading my mind, because that's what I was thinking with this case. Is there no sort of global system that would flag somebody making returns seemingly all the time? I mean, there seems like there would be some mechanism where Walmart would be keeping track that something a red flag would be raised at some point before the loss of $1.3 million.
Right. I mean, $1.3 million is a lot. Like, I can't believe that no one caught this when it was at the $100,000 range, because even that is quite a lot.
Right.
When you're talking about, because I mean, if we're talking about computers, let's say, I mean, it's not as if the computers are $25,000 each. So you're talking about really a significant amount of returns. You're also probably talking about some pretty serious operating capital for this scheme, because it's the type of thing that is only going to make him money if he has cash to front for some of these things. So, I wonder also, what else is it going to uncover? Are there money laundering charges? Is there other fraud going on? Like, how did this whole thing start up? Is there anyone inside Walmart that's helping him out? I mean, because this could be, it could be, something that has to do with Walmart's policies, but maybe on the other hand, there's some kind of inside person that helped him start this up or alerted him to the possibility or taught him how to do it. Who knows?
Yeah.
But I mean, this could be like really the tip of the iceberg. There could be quite a large story kind of underneath that.
I wouldn't be surprised if there was more to this for sure, because this the facts that we know now are a bit bizarre when you think about 1,000 Walmarts, $1.3 million.
I mean, this is this guy's job, right? 1,000 Walmarts. This is his full-time job.
Absolutely, and as you said, you have to have money to purchase the items at the outright, and then
to travel,
to take what you need, to travel, to go to all these different Walmarts. Obviously, I mean, to me, I would imagine there was some concern about a particular Walmart becoming suspicious, which necessitated the 1,000 nationwide Walmarts, but that's kind of a big operation for one guy.
It is, and I also want to know, I have a curious side of me that I want to know, what was his profit? What did he net?
Right,
because
was it worth it?
Right, like the 1.3 million is what Walmart took in, but if he was returning stuff, that stuff had to be purchased at one point. So I need to know, like, if he returned a computer worth however much it was worth, what did he personally profit from returning it and then maybe taking a piece out and selling it? Like, if that was the scheme, that he bought it, stripped it, and returned it, when he stripped it, was it worth the same that the computer was worth? Was it, like, how did he do that?
Right, and how did Walmart come up with that calculation? All questions that would be very relevant at a criminal trial, because right now, I mean, these are just allegations, as we know. This is just an arrest. One thing that you hit on a bit before was, yes, does this mean retailers are going to take a step back and look at some of their policies and procedures, specifically Walmart, but other big box retailers too? Because if this can go on for such a lengthy period of time, that there's this amount of lost revenue out there, should they be looking back their policies and procedures, maybe meeting with their legal team to see if they can tighten something up somewhere?
I wonder, although to be fair, $1.3 million to Walmart is like a drop in the bucket.
Yeah, they do have a lot of money.
So I mean, who knows? But it's a fair question, because other retailers who maybe are smaller in scope than Walmart, but who sell goods that are particularly vulnerable to this type of scheme. Stores like Best Buy, Radio Shack, those type who are selling electronics, they should be particularly aware of this. And I'm particularly interested in this. I grew up in a small family business, and my parents owned an electronics store. This has so much personal interest to me, because I know that we did in our small store have exactly policies to prevent people from buying electronics and then returning them. But we'll see. I wonder if maybe Walmart was not as stringent as maybe they should have been, or if they had very tight policies and somehow this guy circumvented them.
Right, and maybe that requires more employee training or something to ensure that every piece is back in that box when something's being returned.
Right.
Either way, it seems like something that they would definitely want to review to make sure that this doesn't happen again.
Seriously.
And interestingly enough, there is a statute in Arizona where this case is specifically relating to fraudulent schemes, and I'm gonna read a part of it that this was in addition to you received a benefit. The benefit was obtained through fraudulent misrepresentations or material omissions, and it was part of a scheme to defraud. So that speaks to the fact that you've got this nationwide plan, and only time will tell. But we're going to continue to follow this case and see where this leads, because it seems like there's a lot more. We've just scratched the surface here with this arrest. So hopefully we'll be able to cover this in more detail as more facts emerge. But in the meantime, we're going to turn our attention back to the Marine murder trial. Court right now is at a sidebar, but we're going to review the 911 call of the victim in this case. That's Megan Price, the wife of the Marine who was shot on that fateful night. So we're going to review that 911 call now while we wait for court to come back in session. We're listening to the 911 call on that fateful night in the Marine murder trial. That was the voice of Megan Price, the now widow, who testified earlier in the trial about the events of that evening. In that 911 call, it is not lost on even the viewers of this program, even here from hundreds of miles away from the courtroom. The emotion in that 911 call is absolutely felt. You can hear the horror, the terror, the fact that she was injured and suffering and in pain, and also saw her husband and did not really know the state of his medical condition. She did not know how badly he was injured at the time. Ultimately, he died at the scene. Elura Nanos, so we heard in the prosecution's opening statement, there was a lot of focus on the fact that this is a Marine, that he did not die in the course of his duty. He did not die when he was out fighting for our country. He died in a botched robbery. Couple that statement, that powerful statement, to me those words really stuck with me after listening to the prosecution's opening. Couple that with the 911 call. I mean, this is a very emotion-fueled trial.
Yeah, I agree. I think what comes through to me is that idea that this death was so needless. And it's sort of a double statement, because when they talk about how he is a Marine, but he didn't die in the battlefield, that sort of makes this double-edged point that on one hand, Mr. Price's death was really just so needless and just didn't have to happen. And on the other hand, look at the character of this victim. He's someone who is a hero, who should be celebrated, and certainly not someone who deserved such a terrible fate. And it just kind of underscores, how sad the whole situation is. You put that together with the 911 call, which really is very disturbing to hear. And what you have is the sort of quintessential terrible, sad murder,
Right.
where the victim is so sympathetic. The eyewitness is also a victim, and even in some ways even more sympathetic. Right now, at least, kind of the narrative is that the defendants, who are the killers, as per the prosecution's narrative, that they're sort of, faceless, that we don't know anything about them, that they were just robbers. And that is in many ways kind of a standard story, botched robbery, totally needless, who knows why they needed the money, they came up, they killed him. And it's such an easy kind of scenario to picture. And in many ways, I think that is the prosecution's best weapon in this case, that there's nothing confusing about this so far. There's nothing that, as a juror, initially, you're going to look at and say, well, I'd like to know more about that first. On the surface, at least, this seems like a very straightforward case. So I think the defense has its work cut out for it, because it's going to have to make something out of this set of facts that right now all I have is sad, sad, and sad.
Right, absolutely. And that 911 call really emphasizes that. And some of the other facts that we heard from the prosecution, which really loops that 911 call back in, facts like, she was begging for her husband to survive while describing her attackers. We have that, that he was in the parking lot, ultimately bled to death from this gunshot wound. And something that the prosecution focused on that you pointed out too, Elura, which is why the jury heard this, that it was $60 that was ultimately taken from her purse. So
it makes it worse.
It makes it worse.
It just makes it worse. I mean, it would be terrible no matter what. It would be terrible if they had been robbed for $10,000. But the fact that it was hardly any money, it just makes it feel even more needless, even sadder. And I'll tell you, one of the things that really stuck out to me about that 911 tape is that Megan Price, while she certainly sounded extremely upset and in pain and afraid, what she did not sound, at least to me, was hysterical. She didn't sound hysterical. She didn't sound like I couldn't trust what she was saying because she was like out of her mind. She didn't sound out of her mind.
She was pretty rational.
She sounded
and brave.
Very brave, certainly very brave. And the way she answered the questions, to me, seemed extremely sort of natural. Like they asked her, what does it look like? And she was like, I'm in a lot of pain. How did he look? He looked black. Can we get back to saving my husband? It was kind of like, she didn't embellish the details. She didn't have a whole sort of speech to give. She was clearly in the moment, and it was the type of communication which had that ring of total airtight credibility. And not every, even 911 calls don't always have that, but this one I felt really did have that it was simple, straightforward. She gave the right amount of details. She was highly credible, upset so that you got the message that she was very upset, but not hysterical to the point that you were like, well, she didn't know what was happening. She knew what was happening.
Which could be an argument.
Absolutely.
Oftentimes that somebody's in trauma and that perhaps their recollection wasn't quite what they thought it was, even in that moment. So it looks like there's some activity in the courtroom now. We're going to go back. The judge is back on the bench, so we're going to go live into the courtroom now.